Okay, good morning, sir. It looks like I've got two matters here. First, new charge of petty larceny and using or possessing drug paraphernalia. That's 24 CR 09476. Then, depending on the outcome of that case, I have a potential revocation hearing for a simple battery charge in 24 CR 04854. Mr. McGinnis, have you had a chance to talk to your client this morning?
I had, Your Honor. It's my understanding he wants to enter a no contest plea. Hopefully, the petty larceny and the city would dismiss the drug paraphernalia.
Mr. Alton?
City be willing to do that. I would just note that I would ask that he agree to pay the $315. Unless, let me check to see if that was, I apologize, to see if that was recovered.
Please do.
I added up the value of the items that were stolen. Oh, I apologize. It says 329.02 is the total amount actually, and they were recovered, Your Honor.
They were recovered. Okay. And
So
there's
no
no indication that there's any other injury that would require a victim impact hearing or restitution hearing or anything of that nature. Is that correct?
Correct, Your Honor.
All right. I feel comfortable proceeding then. All right. Mr. Connor, the action is to you, looking for a plea on the petty larceny charge. Have you had a chance to talk to your attorney about that this morning?
Yes, I have.
How do you wish to plead, sir?
No contest.
All right. And you understand when you plead no contest, although you don't necessarily admit the truth of all the allegations against you, you do concede that the city has a factual basis that would support the charge if the matter went to trial. Is that correct?
Yes.
All right. So I'm going to enter judgment against you on the petty larceny charge. I find that the plea is knowingly, voluntarily, and intelligently made with the assistance of counsel. In exchange, the city is moving to dismiss the paraphernalia charge, and that charge is dismissed. I'm going to take this one step at a time. I want to dispose of this matter first, then we'll talk about the other case. Let me hear from the city first on sentencing for the petty larceny charge.
Your Honor, he was already under a suspended sentence on a battery. That was to be consecutive to any other charges according to the court's docket. This wasn't, stealing a sandwich or something like that from a convenience store, something food or drink like that that's necessary for survival. Is a larger amount of $329. City's recommendation will be for a 30-day jail sentence up front, consecutive to anything else.
Mr. McGinnis.
I appreciate, Your Honor. I can certainly understand the city's position. I could assume, based on that presentation, that they're probably going to be requesting revocation on the other case as well, where it looks like he has 30 days, which would amount to a 60-day sentence, and then he would be done with his cases, and he wouldn't be on supervision. I think he probably should be on supervision. I think this court should take in consideration that he did commit a new offense while he had a suspended sentence. I don't think just sentencing him to jail is going to stop him from committing new offenses. I'd ask the court to sentence him to 90 days on this case, suspend it for 1 year on the conditions that it would be a law.
More time than
Mr. Connor, hold on. I will hear from you. Do not worry. I will hear from you directly.
Well, Mr. Connor, do you just want to do 60 days in jail, partner? I apologize, Your Honor. He's been a bit difficult this morning to have a conversation with.
That's okay. Mr. McGinnis, let's just you and I talk real quick. Let me hear counsel's recommendation, then I'll talk to Mr. Connor. I have an idea in my mind kind of where I want to end up on this.
Thank you, Your Honor. And I try to talk to him about community court. He's not interested. He doesn't have a social security card. It sounds like he does have an apartment. He's been looking for employment. I think there's a lot of resources out there that he could take advantage of that he hasn't taken advantage of. I'll submit it.
Okay. All right, Mr. Connor.
If I may just add, the police report does indicate as well that this is his would be his 5th petty larceny conviction in the last approximate year and a half. So
all right,
we have that as well. The risk assessment also indicates a history of nuisance and fail to handle court matters. So the city's estimation is that it's just not a good candidate for probation.
Okay. Mr. Connor, I've heard from both of the attorneys on this. I understand you don't necessarily agree with your counsel's tactic. I will let you know that where he's going with this is in an attempt to keep you from doing actual jail time today. The suggestion is a longer on paper sentence, but the idea is you don't actually serve it. So he's not saying that you should do more time. He's saying that you should have a larger sentence hanging out over your head so the court feels comfortable giving you a suspended sentence in this case, just so you understand where he was coming from. I understand you maybe want a different outcome here. The law affords you an opportunity to address the court before I impose the sentence. So whatever you'd like to say, now's your chance, sir.
Your Honor, I I just want to humbly ask for some sort of lenience in the matter because the 30 days, I know I had that. The petty larceny, I was just out of my element from the heat. Plus, all I'm trying to work on, because I've established a place to live. I've been establishing my identification, doing this without program. What I'm trying to do is ask you if I can just consolidate everything with the 30 days and then have, pardon me, a suspended outside of that one to give me uh, a little bit of room because at this summertime I have been doing positive, yet and still I have had the petty larcenies, but I don't commit any felonies. I haven't been felonious in the community. It's always been something small, and I really am outside of 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 those behaviors. I do have things to care about and things to warrant my cooperation as far as staying out the way. How about it? Maybe a 90-day suspended, and I do my 30 replication, and I go from there. If that okay with you?
Well,
And
sure. I'm going to think about this for a second. I got to tell you, it's not much help to point out that you're not a felon, that you're just a repeat misdemeanant. That's not really given the court a lot of comfort. Um, here is what I am going to do. I am going to assert jurisdiction over the 30-day suspended sentence on the simple battery offense. I am going to revoke your suspended sentence in that matter, and you are going to serve 30 days on the simple battery. That is going to be the outcome of that case. On the new charge, I am going to sentence you as follows. I'm going to sentence you to 60 days in custody. I'm going to suspend half of that for a period of 1 year. So you're going to serve 30 days on the new charge. You're going to serve 30 days on the suspended sentence because the prior judge imposed a consecutive, not concurrent condition on that suspended sentence. They're going to be run consecutive with each other. When you are finished with your period of incarceration, there will be a 1 year period where there will still be a 30 additional days hanging over your head. The time has come to protect the community. That is my sense of things. So that is going to be court's order. When the 30 days up front is complete, you will be released on a suspended sentence with a remaining time of 30 days on the following conditions. First, you will report upon release from medium level supervision. Secondly, you will obey all laws. If you are found to commit any further offenses, it would be my indication to then revoke the additional 30 days and have that served consecutively with whatever period of incarceration is warranted for any future offense.
so
That's
basically,
going to be court's order.
they'll give me consecutive 30 days, right? So I'm gonna
Yes.
do like 40 something days, 45 days.
On paper, it's 60 days, and whatever you can manage to string together with good behavior within the jail, that's between you and the jail. That doesn't.
All right, that's
The
cool.
pragmatics of it are a little bit different than the court
That's cool.
side.
That's
Judge,
cool.
how long did you want him on
I'm
medium
gonna just do some
supervision?
voodoo on y'all's quiz, real good.
Judge, how long do you want him on medium supervision?
1 year.
And
If
is that testing?
yes, because I want him sober. So obey all laws, no drugs, no alcohol. I don't know if that's what's underpinning it, but we've got repeat antisocial behavior, including crimes of violence. The time has come to protect the community.
Okay, so just to clarify, you do want no alcohol, drugs,
Yes, please.
no alcohol, drugs, and medium testing for 1 year?
Yes.
Okay, thank you.
And if pretrial services is persuaded that the drugs or alcohol issue is capable of being stepped down, then the court can consider stepping down in the future.
All right, we're going to go on record first in 24 CR 07799. You were charged with the crime of domestic battery, a first offense. I'm looking at that criminal complaint now. It alleges that this occurred on June 19th of this year in the area of 3455 Sky Vista Parkway, number 15H. Do you understand that charge?
I'm a little confused about it because the victim has.
Don't talk about the case, please. I don't want to know about the
No,
facts.
no.
And you might dispute the charge. That's why we have trials.
I'm confused on what. There's no evidence. There is no evidence. Like, is there a statement? Is there anything in writing?
Sir, this is not the time to challenge your case. So don't go down that road. You and your attorney had discussions. She's advising you to enter a not guilty plea. That's why we have trials, is to discuss the facts of the case and figure out the truth of the matter. This is not that time. All I'm asking is that if you understand the nature of the charge against you.
Yeah. Yes, I
Right.
do.
How do you wish to plead to that charge, sir?
Not guilty.
Accept your plea of not guilty. Now, your application for a legal defender indicates that you wish to retain your own private attorney. Is that still your desire, or do you wish me to consider appointing you counsel?
Yeah, I think I'll figure out my own attorney.
Okay, let's go ahead and set this for a pretrial conference, and then we'll go over your custody status.
That'll be August 1st at 1 p.m.
August 1st at 1 o'clock in the afternoon is your pretrial setting. Now, you're going to give that date to your attorney so that your attorney can make that date. Before I leave this matter, let's go ahead and take you through your other case.
It was no insurance.
You got it.
I just didn't have it on me. I do have insurance though.
Well, that's why you're setting a not guilty plea, apparently, according to your attorney. So I still have to take you through your case, sir. We're going to be on record then in 24 TR 07070. You were charged with the crime of not being able to provide proof of insurance when asked by the police officer. This was alleged to occur on May 30th of this year in the area of Sky Vista Parkway and Retreat Avenue. Do you understand the charge?
Yes.
How do you wish to plead to the charge?
Not guilty.
I accept your plea of not guilty. Let's set these matters. Let's go ahead and set that. Can we set that insurance charge at the same setting, Ms. White?
Yes.
Great. That's what we're going to do. We're going to set this insurance charge for that 8/1 date as well. And now we're going to go to custody status. Ms. Drake.
Judge, I recognize that his score came back low at a 2. Although I would still like to see monetary bail in this case. He had a domestic arrest in March of this year regarding the same victim. Same kind of circumstances where he's ransacking the house and kind of like having a breakdown of some sort. I think there's a safety concern here for the victim. So I'm going to ask for $3,000 bondable plus a no contact order with the victim.
All right. Thank you. Ms. Hubach.
Your Honor, given the low score and lack of criminal history, I'd ask for an OR release with conditions of no contact with the victim in this case, that he be on enhanced supervision, no drugs or alcohol without a prescription.
All right. Thank you. Sir, is there anything you wish to say with regard to how I release you? You're not required to say anything at this point, but you're welcome to. And if you do choose to speak, don't speak about the facts of the case, please.
Okay, definitely. So beside the case, the victim my wife has reached out to me on her own record and told me that we've been through this before. The last time this happened, she had to go. She never asked for a restraining order. She, in fact, last time had to go before a judge to get it released because she does not feel safe at the apartment without me, which she has also told the police. She was also, again, she contacted me on her own record, on her own will, while I was in custody, and told me that she was reached out, a victim advocate or whatever had reached out to her and asked her if she wanted one again, and she again said no. This is extremely burdening on our family because I have a child that I need to go attend to, and I have a wife that I need to go provide help to. And she, again, I wish you to look at the facts that somebody has already reached out to her and asked her if she wanted a restraining order, and she said no.
All right. Thank you. Are you working?
I have a commission job where it's in sales. So when I make a sale, I make money. However, I have not made a sale yet. I am looking for a part-time job to supplement this while I am kind of in between jobs right now. So I do have a job, but I have not received payment yet.
Does she work?
She's a stay-at-home mom, sir. And unfortunately, if this restraining order goes through again, she will have to find daycare and figure out a job because I will no longer be able to provide for her. So this is, again, a huge burden on our family at the moment.
Okay, here's what we do, Mr. Sherman. I'm concerned with regard to the repeated acts. We have one in 2023. I'm looking at an arrest on 3/4/2020.
It was dismissed without prejudice.
Look, I can take arrests into consideration when I'm assigning bail. There's an increased risk because this continues to happen. This is the second time within a few months that this has happened. That's concerning this court. In this case, the allegations are aggravated. The allegation is that you punched her in the nose, that caused bleeding. That's a concern to this court with regard to her ongoing safety. Whether it's intentional or not, it's a concern to this court that you're unable to contain yourself. So I am going to assign bail. The bail is going to be $3,000. It will be bondable. I find that the city has met their burden under Valdez Jimenez, showing by clear and convincing evidence the need for bail, and that's based on the prior arrest for this same kind of behavior. And with regard to this particular case, increasing the substantial likelihood of harm to the alleged victim. You will obey all laws and you will consume no alcohol or drugs without a prescription. I am issuing a pretrial no contact order. If she wants that lifted, she can ask the court to have that lifted. And then the judge will decide whether that's lifted or not. No supervision on that no alcohol or drugs clause. That's going to be basic. That'll be the order. Thank you. We're going to be on record in case number 24CR07612. You were charged with the crime of resisting a public officer. This was alleged to have occurred on June 14th of this year in the area of 695 North Wells. Do you understand that charge?
With on that was.
No, ma'am. Do you understand the charge?
Mhm.
You need to say yes or no whether you understand the charge. I'm not asking you if you agree with it or disagree with it. Simply, do you understand the charge?
Yeah.
Yes? You have to answer out loud. This is being recorded.
Yes.
Thank you. Now, I want you to know that while you were originally arrested associated with the charge of domestic battery, the city attorney's office decided to not issue a charge on that, any charges related to that domestic battery event. So the only charge you're facing is that of the obstructing and resisting charge. Do you understand that?
Yes.
How do you wish to plead to that obstructing and resisting charge, Ms. Porter?
Relatively not guilty.
Not guilty. I'll accept your not guilty plea. Let's go ahead and set this for trial. I am going to appoint in this case. Let's go ahead and get you a trial date and then we'll go over your custody status.
I have July 25th at 1 p.m.
Thank you. July 25th, 1 o'clock in the afternoon is your trial date, and that's going to be at the Reno Municipal Court. And now we're going to go to custody status. Ms. Aboitis-Tanner.
Thank you, Your Honor. On the Nevada pretrial risk assessment, the defendant scores a 5. The assessment report indicates that she's been living in Reno for 14 years, no fixed address for the past 3, unemployed, supported solely by government assistance. With regards to her criminal history, I show that her last offense is from 2013, and that was a resisting a public officer. 2010 trespassing, and that's all we have on the criminal history. As far as the allegations in the case, this is a failure to comply with officers' instructions when they were investigating the domestic battery multiple times. So not compliant that the officers had to place Ms. Porter in a wrap. So based on all of that, Your Honor, I'm going to ask that you impose bail in the amount of $500 and that you make that bondable.
All right. Thank you, Ms. Aboitis-Tanner. Ms. Burning, please.
Your Honor, I would be asking for a release on her own recognizance. My client, if I do the math, it's 11 years ago where we've had any charges at all. Also on the MPRA, it shows that she has had no prior failures to appear. So that's a really good record. She understands that if she doesn't come to court, she can get arrested on a warrant. I would be asking for her release on her own recognizance.
All right, thank you, Ms. Burning. Ms. Porter, anything you wish to say with regard to how I release you? You're not required to say anything. And if you do say anything, don't talk about the facts of the case, please. All right, I'm not sure what's happening. Ms. Porter, I'm going to ask you a couple of questions. How can we make sure you make your court appearances?
Is it the building on the east or is it the building on the west side of the street downtown?
It's on the west side of the street, ma'am.
Okay, thank you.
Let me ask you this. We need to be able to contact you. So where are you going to be staying so that we can contact you? If you're unhoused,
Well,
that makes it difficult for the court to monitor
I
you.
was contemplating about going over to our place, homeless shelter.
All right. Have you been there before?
Yes, it's been a couple of years.
That's
no,
okay.
at least over a year.
When you're out of custody, do you have a phone?
Unfortunately not, but maybe they can end up assisting me in obtaining, like gaining one.
Okay.
Because
Your Honor, also,
my life's
depending-
been destroyed by street thugs.
I'm sorry, ma'am?
My entire life's been destroyed by street thugs, being at constant danger and constant risk and constant scare for my life.
Because of street bikes?
Thugs.
Oh, I see. I see. Ms. Burning, I'm sorry, did you wish to say anything?
Yes, depending, no matter what the outcome is of this case, I would just ask the court to note that my client would be interested in community court or to coming to community court on Wednesday in order to get some help.
All right, thank you. You know, this court has concerns with regard to Ms. Porter being able to make her court appearances. We have no way of really contacting her when she's out of custody. We have no way of her keeping in contact with the court. And I'm concerned that we're going to have Ms. Porter not be able to make her court appearances, thereby leaving the city without a case. So I'm going to impose bail of $250. It's going to be bondable. The conditions of your release are as follows. You will obey all laws, consume no alcohol or drugs without a prescription. That's it. Thank you, ma'am. Good luck to you.
So we're here for sentencing on a charge of child abuse in the third degree. It's punishable by maximum of 2 years. The guideline range of 5 to 23 months. First off, Mr. Madaloni, do you have any additions or corrections to the report or challenges to the scoring of the guidelines?
I do not.
Ms. Goodrich, do you? No. Okay, so we are also here, it looks like there's 2 show causes. One that was signed on April 8th that alleges, Mr. Wolf, that you are in contempt of court for violating the conditions of your bond by missing tests and calls from March 8th through April 8th, except for the date of March 11th. And then there's another show cause dated May 3rd, alleging that you are in contempt of court for violating your bond by continuing to not call or text. You have a right to have a hearing where that would need to be established beyond a reasonable doubt, a right to the assistance of your attorney at that hearing. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500. Understanding the rights that you have and the penalties that you would face, Mr. Madaloni, do you know how Mr. Wolf wishes to proceed on the contempt?
I think he has an explanation. I'm guilty with an explanation, I think.
Okay. Mr. Wolf, if you want to stand and raise your right hand for me. Tell the truth, whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay, you can see it. And are you Matthew Allen Wolf Jr.?
Yes, sir.
Okay, has anybody promised you anything in exchange for admission of contempt?
No, Your Honor.
Anybody threatened you?
No, Your
So your own free choice.
Yes, Your Honor.
How do you wish to plead to contempt of court, guilty or not guilty?
Guilty, Your Honor.
All right, and your conditions of bond were to call every day and test when you do so, is that correct?
Yes, Your Honor.
Okay, and did you miss several calls and tests?
I called the line every day. I did miss tests though, as I called the court and told them I just couldn't afford it, Your Honor. There was like 4 times a week. I did test once a week though. I don't know why it doesn't show that on there. I tested 3 times or once a week at New Beginnings in Traverse City, and then the last test I took right here in Sheboygan at Harbor Hall. which was last week. Yesterday, I missed my test yesterday too, because I could not afford it. I'm a full-time father of two with no help, and I could barely keep up with my bills. I simply couldn't afford it. I'm sorry.
Okay, Mr. Mataloni, you satisfied with that factual basis?
I am.
Ms. Goodrich?
Yes.
All right, well, Mr. Wolf, I find that your plea of contempt is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe that you are in contempt. So I will so make that finding and accept that plea. You want me to bring in Mr. Brown and excuse him then?
Yes, thank you.
Let's do that real quick. All right, Mr. Brown, your testimony is not needed in this matter. We did just address it on the record, so you're excused from the subpoena the prosecutor contacted you about.
Thank you.
All right. Okay, so Mr. Mataloni, anything you want to say on your client's behalf for sentencing?
Overall on everything?
Well, I guess overall and the contempt, yes.
I really don't know what to say to the contempt. It's been something that's been going on throughout this case. He's had difficulty reaching them. He's had difficulty getting to the tests, and and I know he has a financial difficulty. I can speak to that personally, but I don't think he's colored outside the lines other than that. And I don't think he's been using. I really think that he's in a situation where he is on his own. He did manage to find someone to watch his kids out in the parking lot for him today, but as I advised, according to the prosecutor earlier, he didn't have anyone to watch his kids, and he was going to have to bring them with him. So I'm going to leave it to the court's discretion. I don't think that he's a threat to the community. I would ask the court maybe decrease the frequency of testing and make it more financially compliable for my client. As far as the agreement we have goes, I'm going to ask the court to follow that. I don't think that he's done anything to, again, ruin that deal. He hasn't violated the bond in contacting the victim or anything of that nature. So I'm going to ask the court to follow our agreement there. And again, the court's been very gracious in the past when it comes to these violations. I know that. It just seems like there should be some sort of solution where he could test right here in town and less often, just from the financial aspect of it.
All right, thank you. Mr. Wolf, it's not required that you would make a statement today. It is allowed. Is there anything you want to tell me? No.
No, Your Honor, yes, Your Honor, just go ahead. I just want to say, I thank you, by the way. I'm going through a hard time, and I'm trying my best. I did all I could. I took the test as much as I could, and I followed the laws. I'm a good dad. Yeah, I'm trying to be a good man. And I apologize that I couldn't keep up with all that I was required to do. I did call the courts, and I apologize to them too. I don't know if you know that, but I apologize.
Thanks, sir. Ms. Goodrich, any recommendations from people?
Is this both on the underlying case?
Yes.
And, okay. First, I would ask the court for permission for Jade Livingston to speak. She is the mother of the minor.
Yes. Good afternoon, Ms. Livingston. Anything you want to tell me before I impose sentence? Go ahead.
I have an impact statement based on, how my life has been since this case has been going on. Matthew Wolf has made an impact in my son's and I's life in a lot of different ways that affects our everyday life. My son, he is impacted by Matthew in multiple different ways. His personality has changed. He's quick to get upset and frustrated when something doesn't go his way. He gets aggressive, and he's never been that way until after the day of November 23rd, 2022. He's afraid of everyone, whether or not you're a male or female, because of what Matthew has done to him. He cowers and hides behind me, even if someone's just trying to say hi to him. My son gets scared every time I drive towards Sheboygan because he thinks he's going to be seeing Matthew Wolf somehow, and I'm always having to calm him down to reiterate the fact that he's not going to be seeing him again. He even flinches at the slightest movements towards him, as if he feels someone's out to get him because of what Matthew Wolf did. All of the impacts that Matthew Wolf has made on my son has also impacted my everyday life of trying to help my son do this every day. Life as he tries to understand and question what has happened to him and why. Every day I question why, and how could anyone ever put their hands on someone as innocent as a 2-year-old at the time of the events? How could someone be so spiteful of an innocent little being that's just learning the ways of life and what they can and cannot do? A 2-year-old isn't going to be able to defend themselves from a grown adult. A 2-year-old isn't going to know how to try and find a phone to dial 911. A 2-year-old isn't going to understand why someone's putting their hands on them in an aggressive way and decipher if it's right or wrong. I question every day what would have happened differently had Leon Landry, Bentley's biological father, called the cops that day instead of just bringing my son to me, as I'm completely clueless as to who Matthew Wolf and Diamond Swinehart are. Matthew's impacted me by making me uneasy about even sending my son to a daycare or even school in that matter, knowing, seeing what happened to my son, because I have little to no trust in people anymore. This case lasting a year and a half, and me endlessly having to be the only one to advocate for my son and hoping to get the justice he so deserves. To me, this isn't a justice system. My son isn't getting any justice in the matter when Matthew Wolf has been deliberately continuing to violate bonds the whole case, as he has only had to sit one time for a bond violation for only 84 days and had just got given a plea deal of 12 months probation. I personally think it's a whole load of crap that he's getting less than what I've been fighting for this whole case. Sorry, Your Honor. I've been impacted financially as it's been a whole lot, or I've been impacted financially as I've been having to drive back and forth from the police station and all the court dates we've had, and with the fact of not trusting anyone, having only a select few people I do trust. So I'm not able to work as much as I'd like to be able to financially support me and my son. I also feel as though my son and I have been impacted by the Sheboygan Police Department and their failure to get my son and I a police officer on the case who was going to be able to successfully and thoroughly do their part for the case in the beginning, but instead gave us a police officer who was going to be transferring from Sheboygan to a different police station, who had seemed to be in a rush and completely get everything mixed up. I then had to advocate to get another police officer on the case, as they hadn't originally found another police officer to take the case. 5 months. It took about 5 months to even get a warrant to have Matthew and Diamond arrested to get anything in motion from when I had filed the complaint. I question every day why it is that Sheboygan County was failing my son and I when they're supposed to be the justice system and there to serve for their people. I question every day how it is that Diamond could sit there and tolerate her fiance husband doing something so heinous to someone so innocent. I question how it is that Diamond, by what I was told to be the one who was supposed to be watching my son, could also be let free of any consequences based on her fiance husband's actions and not doing anything about it, not attempting to call 911, or even Leon Landry, Bentley's biological father, the one who had set up babysitting. My son and I are also impacted by Leon Landry and his actions in the case, as he hasn't been a big help in it at all from the beginning, because he didn't do what any father would / should do in a situation like this that Matthew had put my son through and called 911 the night of November 23rd, 2022. My son's impacted by him because since this day this has happened, he has made no efforts into trying to be a part of Bentley's life. He's made no efforts into helping give information regarding Matthew to try and help his son get the justice he deserves. He hasn't even given Bentley an apology for the situation he put him through, and not even attempting to help his situation. With that said, Leon's impacted me because he's given me all the weight in the situation from the beginning and has left me hanging clueless about anything pertaining to the situation. Thank you.
Ms. Goodrich, recommendations from the people?
Yes, Your Honor, thank you. The defendant is 39 years old. He has 9 prior felonies and 3 prior misdemeanors. I believe that the court has been more than patient with him on the drug line issues dating back to April 2023. Initially in district court, he was given a fine for a dilute test, and then in July of 2023, he had a positive drug screen. He did serve some jail time. There was another violation September 28th of 2023 for missing drug screens. Then we're actually here on a sentencing from a violation of March 4th of 2024, where he was failing to call the bond line in early March. The court gave him a stern warning that he had to figure this out, he had to comply, and that he would not be incarcerated for a second time and given a chance. The prosecutor's office during that time also gave him a chance by doing a delay plea agreement that was against the victim's wishes, as she's explained why. And then here we are today between plea and sentencing with 2 more violations for missed calls, missed tests, without really any new explanation from that. He was warned by the court in March of 2024. I would ask the court to take that into consideration at the sentencing. Thank you.
All right, thank you, Mr. Wolf. If you please stand for the court sentence. Mr. Wolf, you stand here today convicted of a felony crime of child abuse for injuring a very young child with bruises on the child's head and back. You have 9 prior felonies, which is a terrible record. And your guideline range is a straddle cell. 5 months on the low end, 23 months on the high end. The plea agreement is for a delay of sentence. I'm not going to do that. I'm not going to place you on a delay of sentence for 2 reasons. One, your extensive felony record and your abuse of a young child, and also then your complete failure to comply with my orders on bond. I have no reason to believe that you would comply with probation orders. Over and over again, you seem like you can just come to court and tell us why you're not obeying court orders, and that should be okay. I'm not sure why you think that. Maybe that we've been too lenient with you. And I revoked your bond at one time, but then gave you more chances. I thought that maybe revoking the bond and having you sit for 85 days would have mattered. It doesn't seem to have gotten your attention. In any event, your post-plea contemptuous conduct has negated your ability to withdraw the plea for me not following the plea agreement. And I have no confidence that you would succeed on probation. So, honestly, somebody with your record that hurts a child, I'm really thinking about whether to send you to prison. I'm not going to do that today, but you are going to do a year in the county jail forthwith. You get credit for 88 days previously served, for $68 state cost, 130 crime victims assessment, $350 court cost, $60 DNA fee, and on the contempt, it's 93 days credit for 0. Those will be concurrent. You can appeal if you wish by filing an application to the Court of Appeals. If you want me to appoint a lawyer, you have to ask me within 42 days. We're going to give you some appeal paperwork to that effect. One for you to initial, one for you to fill out if you want to take an appeal. And that's the sense of the court.
Does he need to sign the appellate rights form? You give her We acknowledge receipt of the appellate rights form.
Thank you. Thank you.
And are we going to do Mr.
Yeah, it'll be Mr.
Good morning, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Yes, I did, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Street.
Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 before Judge Slate Thursday.
June 27, 2024, 1:30 Slate Thursday. Bond with its conditions will continue. Thank you. Yes.
The note in my file from the other APA that you saw in violation review that's today.
Yeah.
The May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lived in Macomb County. We
I'm on GPS. Oh,
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm going to fail for would be marijuana.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm gonna be upfront honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've helped to.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's gonna happen, and then we'll figure out. In the meantime, council can prepare an order so that he can test in Macomb. Okay,
And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not they'll be remanded.
pardon?
The waiver's all set now?
Well, technically, no.
Got it.
Because, technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're gonna do.
Okay, thank you.
Thank you.
Thank you, Your Honor. Nicole, on behalf of the people. Silvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs. As we were walking out of the courtroom, I went to release the deputy who was present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Miss Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's a no contact order. That, in addition to the corrections violation, I'm requesting that he be remanded and that its bond be revoked.
That's not my problem.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
You're right. Not sweet.
If you wish.
She wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something that I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Okay, I
So-
understand that. Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. It'd just go up before Judge Slay. I'll just leave it there.
Thank you, Your Honor.